Everyone, thank you for joining us today for our webinar on new overtime requirements effective December 1st. We're going to speak about whether or not you're classifying and paying your employees properly. Specifically today, we're going to cover administrative staff. I know many of us on the line are employing administrative staffers, and we may be classifying them as an exempt employee and have them on salary. Well, new requirements that are coming into place as of December 1st, 2016 are going to make that a little bit more difficult, and we're going to talk about why. Before we get started, I'm going to introduce myself. My name is Jennifer Kirschenbaum. For those of you who do not know me, most of you on today's webinar do, but if you're viewing this on YouTube or elsewhere, you may not. I am the managing partner for the healthcare division of Kirschenbaum Kirschenbaum, a New York law firm. We do work nationally. And we have all different types of services we provide. Specifically for the healthcare industry, we serve as general counsel to most of our clients, which is why we're involved in certain employee issues, hiring and firing and classification. So I'm going to get started. I'm going to try to keep it to less than half an hour today because I know many of us are on lunch break. And if you have any questions after our discussion, you can always feel free to call or email me directly. For today's agenda, I'm going to spend a little bit of time speaking about the Administrative Employees Exemption Duties Test, which for the most part has not changed, the minimum salary threshold changes, and the executive salary changes, high compensation changes, overtime requirements, our potential exposure for noncompliance, and our preventative action that we recommend that you take immediately to ensure compliance. Our exemption for administrative employees under the Fair Labor Standards Act test is a three-factor test that we're going to start right now. The first factor is whether or not the employee is paid a certain amount of money. So if you're paying an employee less than $455 a week, that's per week, approximately $23,000 a year, you are not authorized to have this person as an exempt employee. They must be hourly and paid overtime. Now this is changing as of December 1st, which we'll get to in a couple of minutes. If you're looking to classify an employee as salaried solely because they make enough money, that's the only standard. The highly compensated employee exemption right now is set at $100,000 per year. So some of us may be an office manager, and we may be making slightly less than that, which is still in most markets considered a very good salary. Well, you will not be exempt from overtime solely because of your high compensation. If you are making less than $100,000, that number is going to go to $134,000 as of December 1st. So it may be time for, unfortunately, a raise if you're looking to have someone exempt solely because they're a highly compensated employee. The second factor, which we're going to get into, is whether or not the employee's primary duties in the performance of their work is directly related to the management or general business operations of the employer or the employer's customers or patients in our case. Primary duty is defined, and we're given more guidance by the Department of Labor. And by the way, I should clarify that the majority of what we're talking about today is federal standard, so it's going to apply in every state. Certain states have more stringent rules, and we will get to some New York requirements coming up because that's where a lot of our clients are located. And I will have minimum wage information that's current and up to date for a lot of states, and that's going to be coming up a little bit later. These references that you're going to see on the bottom of certain screens are leading to the federal government Department of Labor website, and you can find information on the content that I'm providing there, and you'll see the source documentation for the content that we're discussing today. So getting back to the second factor is whether or not the primary duty is related to the business operations. Primary duty is defined by the Department of Labor, and it means whether or not the most important duty the employee performs is the primary duty and if it's related to the business operations. That determination of an employee's primary duty is going to be based on all facts in each particular case. And the government, if they're challenging your classification, is going to look with major emphasis on the character of the employee's job as a whole. So it's going to be a big picture. Whether or not it's directly related to management or general business operations is going to be a factor test as well. And what they're going to be looking at is whether or not the work is directly related to the management or general business operations by including functional areas of the operations of the business, such as tax determinations, finance, accounting, budgeting, auditing, insurance, quality control, purchasing power, inventory and supplies, advertising, marketing, research, safety and health. Are they responsible for the OSHA training? Personnel management, human resources, employee benefits, labor relations, public relations, government relations, computer network and internet and database administration, legal and regulatory compliance, and similar activities. Many of you listening to this, I know, are practice managers and are thinking to yourselves, well, obviously, I do the majority of that list because I'm responsible for everything. If that's the case, then yes, you probably are going to meet the second factor test. The third factor is similar, but slightly different. It's whether or not the employee's primary duty includes the exercise of discretion and independent judgment with respect to matters of significance. Now, here is where certain of our employers, for many of our solo practitioners, are possibly shooting themselves in the foot. If you work with a real micromanager, or if you are the real micromanager, then you may be destroying your ability to qualify an administrative staffer as exempt and a salaried employee if you are not allowing them to make independent calls. So discretion and independent judgment, again, we have some additional information on this from the Department of Labor. In general, it means the exercise of discretion and independent judgment involving the comparison and the evaluation of possible courses of conduct and acting or making a decision after the various possibilities have been considered. So someone who really has the ability to assess situations and choose a course of action. Here, the employee would have to have the authority to make an independent choice, free from immediate direction or supervision. So, a pipe bursts in the middle of the night. They cannot find the owner, and they are the practice manager. What do? Do they know to call the police? They know to call the insurance company? Do they go to the facility? Do they go there and call the plumber? If you have someone who really can't do any of those things, this is just one scenario, obviously, and maybe the person is not adept at, then possibly you're not looking at someone who's operating independent enough to qualify for the exemption. Other factors that are going to be looked at is whether the employee has authority to formulate or implement management policies or operating procedures. So if you're the office manager and you want to make a modification to the employee handbook, you have staffers who are just not getting in on time, or we need to change a cell phone policy. If you're authorized to do that with limited oversight, then these are factors that would come into play and you may be properly classified. Now, in this language, you also see that matters of significance is an issue, whether or not you actually are having an impact on how the operations are going. So matter of significance also refers to a level of importance or consequence of the work performed. An employee does not exercise discretion and independent judgment with respect to matters of significance merely because the employer will experience a financial loss if the employee fails to perform the job. And an example that is given here is just because an employee is given control over an expensive piece of equipment does not necessarily mean that it's a matter of significance. So let's say we have radiology technicians who are working in our medical practices and they have access to an MRI machine. Just because they don't spill their drinks on it during lunch does not mean that they are necessarily going to be exempt and be authorized to be paid a salary. Now, we are not going to talk about the professional exemptions today because I felt that there was enough material here for us to focus mainly on administrative, and I think that's where a lot of our misclassification does occur. So we're going to stick to that for the most part today. This is a change that's effective as of December 1st, 2016. The minimum salary threshold for exempt employees is changing. We now are going to have to change our expectation. So for someone to not be paid overtime, they have to be paid $913 a week, or $47,476 annually. That is the minimum. So if you have people salaried at $42,000 a year, which, by the way, is a very high percentile for salary if you look across the board. But the purpose of here is to capture overtime for individuals who are going to potentially need it. So if you have a $42,000 a year staffer that you did not have capturing overtime for them, then we are going to have to now work to reclassify them as non-exempt, and they're going to have to go to an overtime system. The highly compensated, and we're going to speak about that, we're going to speak about that in a moment, what that means, but I'm just going to get you through the highly compensated employee exemption. Previously, if someone was making over $100,000 a year annually, they were exempt. They were paid enough, and that was it. Now, for cost of living increases and for just to help compensate and raise the national level, which we're hearing a lot about, the minimum requirement is $134,000 a year and $4 for annual salary to be exempt as a highly compensated employee. Now, if you reach the standard and you're paying someone over this number, you do not have to worry about the other factors in the test. So the other second and third that have to do with independent judgment and primary duty being operations of the business. That is if you are working off of the minimum salary threshold. You're paying someone now $50,000 a year, and are they independent enough? Do they make enough of an impact to your organization where they do not have to qualify for overtime because they fall within the minimum salary threshold and the highly compensated employee exemption? So we have a bucket there that has to be looked at very carefully. Overtime set by the federal government is 40 hours. New York is the same. That's 40 hours per week. And we're going to talk about what week means right now. A work week is a fixed and regularly recurring period of 168 hours, 7 consecutive 24-hour periods. It does not have to coincide with a calendar week. It can begin on any day at any hour. Different work weeks can be established for different employees. They do not have to all be on the same set schedule. Averaging of hours over 2 or more weeks is not permitted. So again, it's continuous, 168 hours, 7 consecutive 24-hour periods. Okay? Overtime pay that's earned in a particular work week must be paid in that pay cycle. So I'm going to repeat that because I think some employers are not necessarily doing that. The overtime pay that's owed is supposed to be paid in that regular pay period. So if you're doing it biweekly or bi-monthly, you have to pay in that 2-week period. Just because you have an employee working on a Saturday or Sunday or a holiday, you are not required to pay overtime unless that person has exceeded the 40 hours for that particular week. So some employers think, well, people are less inclined to work on a Sunday, so I should have to pay them time and a half, or maybe some employee has snuck that concept into your mind. That is not correct. Overtime is only due after the person has accrued more than the 40 hours in the work week. Now, employers could also cause themselves their own problem. If you decide to define the work week as 35 hours by a policy, then you may be required to pay overtime after that, that time period has elapsed, depending on how you define it. So you want to be very careful with your own policies. This is minimum wage. I'm going to leave this up just for a moment so that way we can get a look at it. But as you can see, New York is now at $8.75, and this is effective as of January 1st. This is straight off of the Federal Department of Labor website, so anything that's incorrect, I apologize, but I did not check each state. And if you think that this topic is not that important, we're going to get to why it is in a couple of minutes, and you'll see this is a major area of exposure for employers, and it's very easy to understand why. The most important thing that we can do to protect the employer is to properly track overtime. This is the most vital resource your company can do against inquiry or assessment, which we're gonna understand what that means in a couple of minutes. If your employees could very easily claim that they're working more than a set number of hours, and it would be difficult unless you have a set policy and procedure on how they have to maintain their hours to rebut that that's going to be made by the government. So I recommend some variation of a time clock system, whether or not your electronic system has a clock in, clock out. If you're utilizing your payroll company, please do not bank on that. We have recently represented a number of clients that have been audited by the New York State Department of Labor and based on employee complaints, and they've had to pay, unfortunately, certain fines back and penalties and back wages because they were not properly tracking. One such physician actually was relying on ADP and had not been overseeing the ADP tracking system or the administrative person in their office that was supposedly communicating with ADP, and they did end up having exposure. So making sure that you, as the owner or the practice manager, the captain of the ship, the person in charge, 100% understands and is overseeing the tracking mechanism for employees is incredibly important. Overtime eligible workers, they're not required to punch a clock. That's not a legal requirement. It's one that I'm trying to put on you to make sure that we are properly clocking and have an accurate record of who is coming in when they're working, and how much you have to pay them. So the payroll companies have it. Some softwares will allow you to track, but please make sure that you have a system set up. If you're not sure whether or not you need to be paying overtime or how much overtime based on the hours that employees are working, well, the federal government actually has a calculator right online. It's not as great as having your own system in-house, of course, but it's very easy to use. I actually went on to the website yesterday just to take a look at it, and here is the website, which you can copy down. I do recommend checking it out. It's kind of cool. You plug in the rate and the days and when they're working, and it tells you right off the bat how much you have to be paying. So I want to do some quick FAQs with you. These are questions that we get asked on a pretty frequent basis, and I think that they'll be helpful for us to go through. The first one is, my employee worked 12 hours on Monday when she was scheduled for 8 hours. Does she get overtime? No, not necessarily. Just because you work more than 8 hours in one day doesn't mean you qualify for overtime. Overtime is set on a weekly basis. So if she worked 12 hours on one day, 2 hours on the next day, 4 hours on the next day, and she hasn't exceeded the 40 hours in the week, then no, she's not entitled to overtime for that week. Next question. My employee worked 12 hours on Monday when she was scheduled for 8. Can I end her hours early on Wednesday to make up the time? Now, this is a New York State answer. We checked with the Department of Labor in New York, and the answer was yes, you can absolutely change an employee's scheduled hours so long as you provide the employee advance notice. There's no notice specified requirement as to how you give it, but I would recommend that you try to give notice in a traceable format. So, for instance, the easiest way is by email. Confirm the employee's hours. Now, if you're not doing this and you have someone who's been with you a long time, that's okay, but you may still want to try a text message or email to just make sure that you know when the person was there, how much they worked, and whether or not they qualified for overtime or not. The next question, are there maximum hours an employee can work? Unless it's a minor, so anyone under 18, I believe the federal requires under 16, you must comply. There's no maximum hours that someone can work, but you must comply with meal requirements and break requirements throughout the day. But no, there's no hour requirements. If you have someone working 85 hours a week and they're willing to do that and they want to make the overtime, that is just fine. Can you fire an employee for no reason? This is, I just threw this in here because it's always asked pretty much at every opportunity. Absolutely, you can fire as long as you're in an at-will state, which we are in New York. You can fire for no reason or any reason at all except for a protected reason, which would be based on a protected class. So you can't fire someone because he's a man, but you can fire for any non-protected reason at any time. If you do have a contract with your employees, if you've given them a term sheet when they first came on, or you have a contract, then you have to abide by the terms of the agreement. The agreement with an administrative person, if you do have one, which we're going to talk about that in a second, what we think you should have in place, it should very clearly state that it is an at-will arrangement. Exposure for misclassification is massive. I believe, as many of you are aware, because you're on our newsletter and you get my viewpoints, that exposure from employees is one of the biggest areas of concern that you have as a practice owner on a day-to-day basis. And failure to properly classify is in my top 3 of ship sinkers. The reason is because it is very easy for staff to speak, and you could very easily have a walkout and class action on your hands very, very quickly. There's a lot of lawyers out there, in case you haven't heard, and a lot of them are doing employment law plaintiffs work, and plenty of them are happy to pick up a case where a professional has not properly classified and back wages erode. Why? Because it's very easy. The statute, specifically in New York, which I've cited for you below, the labor law, allows for massive penalties. All of the back wages for unpaid overtime would be due. You would be automatically, pretty much, penalized 100% of the back wages as an additional penalty. So you're paying 2 times. On top of that, back taxes, interest, and the plaintiff's or your employee's attorney's fees would have to be paid in full, and that is by statute. If you willfully violated, if you had absolutely no regard and you were not listening to this webinar right now and you could give a hoot about classification issues, they could fine you up to 300% of the back wages. Massive, massive penalties. So how do we avoid that? Well, we don't do it in the first place. And we're going to speak now very briefly about how to avoid putting yourself in this situation. So necessary employer compliance, Department of Labor required notices. This is a link to the federal site. Many of you, I've been to many of your offices, have your required notices posted. Please confirm. Proper onboarding. This is not a full HR talk, so I'm not going to go through all proper onboarding protocol, but you are required to give, especially in New York, notice of wages earned on an annual basis beginning in January, I believe. I can confirm that if need be, to each employee and certainly at the start of employment. Training protocol. We need to make sure that we are properly training those individuals who are doing our onboarding for us. If we are not doing it, then we need to make sure that our office manager, practice manager, or administrative staff who's assisting with this knows what they have to be doing when they are properly onboarding. We're going to maintain an easily trackable or traceable system for clocking in and clocking out, whether we're relying on a third party or our personal software or just a good old time clock. We're going to make sure we enforce. We're going to discipline for failure to abide by the policy and utilizing the clocking in and clocking out mechanism. What does that mean, discipline? We're going to write up employees. We're going to have them sign they've been written up. We're going to dock them. We're going to send them home. We're going to possibly fire and make an example out of someone. Why? Because you have major, major exposure here. Also, I recommend that you adopt an offer letter for each individual who's coming on that specifies their duties. In particular, for any of our practice managers that are on here, for yourselves as well, we should know what your authority is. And this will help you later on if you're having a dispute with the practice owner, or if you're a practice owner listening and you're concerned that an employee is not going to be classified properly or properly stay within their scope. I hear it all the time. A lot of my doctors call me and say, Jennifer, I hired this great person. I finally have the right fit. She's going to be the best practice manager. I'm not going to have to worry about anything. I finally go on vacation. I get a call 6 months later or 3 months later or 3 weeks later. Boy, was I wrong. She doesn't know what she's doing. She's slowing me down. She didn't live up to expectations. She promised me the world. Now what do I do? Well, if we documented the onboarding properly, sorry, then we clearly say that the expectations haven't been met, and we explain why there's going to be a termination, and we properly document. That's the safest way we can do it. We want to make sure we have an employee handbook. Sometimes I counsel that we want to make sure there's a critical mass of the practice. I don't like to see money be wasted. So if we're talking about our 1 or 2 man group with 1 or 2 staffers, I understand. But anything bigger than that, we should really talk about having formalized policies and procedures. Employee HIPAA agreement. This is unrelated to today's talk, but it's certainly noteworthy because we have all of our staff members are in contact with protected health information. And we can have another discussion about what needs to be in place, but please bear in mind that just because we're talking about labor today and employment doesn't necessarily mean that this is an all-encompassing overview of what needs to be in place. And of course, at all times, training and education of our staff is key. So if you have any questions for me, I'm happy to take them. You can email me or call me. Some of you are going to require an actual consult where we're going to have to speak with you and get some information on what your employees are actually doing and discuss whether or not there's going to be a reclassification requirement. Now, one of the main concerns you may have is, well, Jennifer, if I reclassify, aren't I going to be drawing attention to the fact that I'm not necessarily paying them properly at the moment? That might be so, but I can tell you right now that it's better for us to have a plan together now and rectify than for you to continue on and not necessarily properly be paying a non-exempt employee lack of overtime, and also not properly implementing a time clock system. So I feel very strongly about this. It's one of the major areas of exposure. You can check with your insurance carriers. First off, on that note, you have to make sure you're carrying EPLI, which is Employment Practices Liability Insurance, and that protects you against your employees, mostly for claims of harassment and discrimination. But you can also check with your brokers to see whether or not your policy will also cover you for a labor law complaint. Most of the time, I believe that they do not. So, but it's worth checking. Many of you know my biography, but here it is again. I've shortened it here for you, but we represent all different types of healthcare practitioners, MDs, DCs, PTs, dentists. We're on the panel of the New York State Dental Association and have been for years. We work very closely with Queens County, and we're happy to help with any questions that you may have. Here is our website, and if you are not on our free newsletter, which goes out twice a week, please email me and ask to be added, or you can go to the website and check out prior articles and newsletters and sign up there. So we kept it under the half-an-hour time limit as promised, which I'm happy to see. And if anyone has any questions, please feel free to reach out. And next time I hope to see you in person so we can have a actual real question and answer session. Wishing everyone a nice day.